Those are the only amendments.
There is no amendment.
Council, Mr. Mnisi, let's hear you. Do you agree that the materiality of the charge sheet, according to the state, is still the same, except that there are addendums added which clarify some of the charges?
I definitely agree, Madam. I think the essence is
Still the same.
Still the same, yes.
Yes, sir? You compare there.
Yes, I do confirm that. Thank you.
Ms. Mchololo?
I confirm, my Lord, that the charges are still the same. The amendments were in respect of substantial facts.
Okay. Now, have you taken proper instructions? Because the first accused says he wasn't served with an indictment. Have you taken proper instructions from him, Mr.
I have, my lord. I have, except the fact that he did not receive the indictment, but we were discussing from the new indictment in the morning, my lord.
So you did discuss the new indictment with
We
him
did discuss
this
the new
morning?
indictment. In fact, they are the ones, him specifically, that highlighted these differences to me.
Okay. Does the position obtain for all the councils? That in the morning you discuss the new indictment with your clients?
We did, Madam.
You did.
Yes.
Yes, thank you. I did, my lord. Thank you.
And Ms. Mchololo?
Yes, I confirm, my Lord.
Okay. So you were given instructions, all of you,
I
by your
confirm
client,
it.
the previous clients.
I confirm it.
Yeah, this may seem to be a redundant question I'm posing to you, but I'm obliged to pose it because this is a new trial. And in terms of the statutes, Constitution, Section 35, 1F, for instance, the court must satisfy itself that the accused person who has either been re-arrested or re-detained after being served with a new indictment, he again gives instructions to his or her counsel. So that position is verified, okay?
Manje ke inkantolo befuna nje ukuthi icacisele lento leyo ukuthi ngoba bamangalelwa bephinda futhi baboshwa kuleli cala lona lela cala baboshwa lona phambili phela ke ukuqala phansi ngaleli cala kusho khona ke ukuthi abamangalelwa amalungelo wabo afanele ukuthi ke aphinde futhi acaciselwe wona ukuthi bacaciselwe wona lawo malungelo ukuya ngo section 35 subsection 1F kulapho ke inkantolo ifuna ukuthi kumele iyaneliseke ukuthi ngempela abamangalelwa bacacisela amalungelo wabo ukuya ngomthethosisekelo manje yiyo ke into inkantolo efuna ukuthi iqinisekiseke leyo abamangalelwa batshelwa ukuthi nisanelungelo umuntu ngamunye ukuthi angathola igqwetha lakhe azokwazi ukuthi alibhadale ngemali yakhe yabona lawo malungelo nokuthi uma ungenamali ke kanjalo uyakwazi ke ukuthi wenze isicelo sokuthi inkantolo ikusize okanye ilegal aid ikwazi ukusiza ukuthi uthole ummeli lawo malungelo kumqoka kakhulu andikuba sizoqhubeka ke manje okanye sizoqala kabusha ngaleli cala ukuthi abamangalelwa batshele bona yazwa
Did they confirm that?
manje ke niyaqinisekisa ke ukuthi abameli bezabini bancacisela lawo malungelo mhlambe baqinisekisa ke nokuthi bayonikhulumela kuleli cala ngoba icalela phansi njena nasho ke nani ukuthi hayi siyavuma ngaqhubeka zonke lezo zinto ngabe kwaba njalo mangala lokuqala kwaba njalo yini futhi wacacisela amalungelo wakho njengoba inkantolo yabuza ngaphambi kokuthi i-charge sheet watshelwayo ukuthi yabona le charge sheet lena iqukethe amacala athize amalungelo kuya ngomthethosisekelo ilungelo lokuthi mhlawumbe utholele ummeli wakho ilungelo lokuthi mhlawumbe uwenze isicelo sokuthi utholiswe ummeli lawo malungelo natshelwa wona yebo noma mhlawumbe wacacisela ukuthi kunjalo mangalo sithathu sengisho ukuthi uma ngabe leli cala secala phansi okungenani ukufaneleke ukuthi ofanele ukutshela amalungelo wakho akutshele amalungelo wakho ukuthi uboshiwe-ke unelungelo lokuthi Khulukazi mhlambe nanoma ngabe iqhamuke kumeli, as long as wena uye wakwazi ukuthola umndeni wakho, watsha konke ekuqaleni. Futhi amalungelo watsha wona ujelile. Angukuba sizoqala ngaba yizolo, ngaba amahora mhlawumbe adlulile, ngaba amalanga adlulile, angukuba sikhali ngaphatsha amalungelo wakho watsha wona. Your Lordship, accused 1, 2, 4, and 5, their rights were explained. As far as the resumption of this matter, my Lord, is concerned. Accused number 3, he says that such rights, in terms of Section 35, were not explained to him.
Okay, fine. Then the court is obliged to explain your rights to you.
Lalela ke, inkantolo ke, isesimeni sokuthi ingacacisela ngawani. Futhi ifanele inkantolo ukuthi mayicacisele ngawani. Understood, my Lord?
Yeah. In pursuance of the Section 35 rights, I wish to quote the case of the Director of Public Prosecutions, Transvaal versus Viljoen, 2005, 1, SACR 505 SCA. It's a judgment of the full court in Bloemfontein, SCA. In this case, what actually happened also, a person was charged with murder, and when he appeared in the magistrate's court, he pleaded guilty to the charge. And when the trial commenced in the High Court, then he pleaded not guilty.
Ukuthi-ke kunomlisa-ke oke watholakala okanye waboshwa wavelela-ke inkantolo yelokuzaneyelokuziwe. Kanti-ke uthe makavela khona-ke babambuza-ke ukuthi uyazivuma noma cha, wathi cha yena wathi uyazivuma cha. Kana-ke lase iyasuka-ke lapho kwi-magistrate court laya-ke kwinkantolo ephakeme i-High Court. Uthe makafika khona-ke bakabuzwa ukuthi uyazivuma noma cha.
Yeah, the long and the short of it is that the SCA, because there were some technical problems regarding the plea, they made an order that the case should start de novo. And the presupposition is that because it is a new trial, your Section 35 rights have to be again explained to you like I tried to do. Okay.
Yes, all right. Understood, my Lord?
All right, that's one trial. And also in the case of the state versus, it's Gumbi versus the state. Yes, versus Gumbi, and others. The citation is 2018 to SACR 676 SCA. In this case, which happened here in Pretoria, my late brother, George Webster, handled the same case. Unfortunately, he couldn't write the judgment because he was incapacitated physically. And what consequently happened, another judge was appointed to rehear the case, and what he or she did was to continue as if nothing has happened by eliciting from the various counsels that the evidence which has been led in the previous case, do you agree or give consent that it should be made part of the trial, which is now continuing before a new judge? The assent by this counsel was supposed to circumvent the unfortunate delay of the trial. But the SEA held that that was unlawful. So the evidence which was led in the previous trial, yeah, it's a nullity.
Yabona ke ujaji ke phambili kanti uzakwabo osengasekho vela kujudge naye ke wabhekana nenselelo nje enjena lapho ke okuthiwa ke inkantolo kafushane ukuthi uyabona ke ikhala maqala phansi ubufakazi obebakhishwa phambili kwamele ukuthi abankulumelayo basho ke ukuthi lelo ngamanye lokho phakathi makusetshenziswe la enkantolo ukubeka njengocala cala phansi kanti ke i-SEA yathi cha yabona ke uma ngabe sizoqhubeka okanye sithathe phansi icala bonke ubufakazi wakhishwa la enkantolo phambili kufana nokuthi ubufakazi obungekho yazwa ukuthi qala khane zoqala ukuqhubeka la enkantolo yazwa that was explained to me, my lord, that is in accordance with accused number 3.
Yeah, and this submission is buttressed by the fact that this court on Friday, a judge had an application declaring the previous case in which you were all involved to be a nullity.
Yabona ke ngolesihlanu evikini ngazothiwa ngempela ke leli cala ke lizoqala kabusha namhlanje futhi ke kuthiwa ubufakazi okanye leli cala elinalo elinquestion ngefamily alikho lelo cala ngamanye amazwi fikela ke enze thweswe